Mr. Copeland, good morning, sir. My name is Brad Gardner. I'm a magistrate judge here in Clayton County. Today is a day that was set aside for you to appear before a judge as it relates to the allegations that are pending before you. My understanding is that you did not want the representation of an appointed lawyer. Is that correct?
Yes.
Have you retained a lawyer?
No, no, sir.
Do you
No.
intend to go forward today on your own?
Yes.
Okay. Miss Lewis, well, first, Mr. Copeland, sir, you're going to be held to the same standard as any other practicing lawyer. And I'm going to guess, but I'm not certain that you have not had the experience or training as it relates to a lawyer. So I am going to allow you to move forward here today for a determination as to whether your charges should be bound over to the state court of Clayton County. Do you understand that, sir?
Yes. Yeah.
Do you have any questions of me before we begin?
No.
Okay. Ms. Lewis, would you please swear in your witness?
Yes, Your Honor. Morning, Officer Alexander. If you can take yourself off mute and raise your right hand. You swear and affirm that the testimony that you shall provide to the court today shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, place your hand down and please state your name for the record.
Officer S. Alexander,
Okay, and Officer Alexander, which agency do you work for?
Clayton County Police Department.
Okay, and what are your duties as a Clayton County police officer?
To enforce laws.
Okay, and as part of your duties as a Clayton County police officer, did you have the occasion to come in contact with Lewis Copeland?
Yes, I did.
Okay, and do you see that individual on the Zoom call today?
Yes, I do.
Okay, can you identify them by what they are wearing?
White face mask and orange jumpsuit.
And Your Honor, may the record reflect that the witness has identified the defendant?
You can move on, Ms. Lewis.
Yes, sir. Okay, and where did you make contact with the defendant?
At his house at, I'm sorry, 228 Morrow Road, apartment B.
And is that in Clayton County, Georgia?
Yes.
Now, you placed him under arrest, I believe, for obstruction and criminal trespass.
Can we lower the volume of the communications at the jail, the radio communications?
That was Jones.
Okay, and I'm sorry. I was asking, what was the basis for you taking out the warrant for obstruction?
Oh, I responded to that location in reference to a domestic disturbance.
Okay, and who was that disturbance involving?
Mr. Copeland and his mother.
Okay, and what was the nature of that disturbance? What occurred?
I guess they were arguing about a check he receives monthly, and she advised him that well, I guess he was requesting the check, and she advised him that the check provides him care for his medication as well as his well-being. He then didn't like that answer. He said that if he didn't get the check, he was gonna break something.
Okay, and did he break something?
He did.
Okay, what did he break and how did he break it?
He broke the front door to their apartment. He did that by kicking and forcing his shoulder into it.
Okay, and did you observe that damage?
Yes, I did.
Okay, and did you receive an estimate for about how much damage he caused?
Yes, per his mom, she advised it was about $200.
Okay. And at that point, did you make contact with him?
Yes, I did. I then advised him to turn around and put his hands behind his back. He then told me no. I then advised him that he was under arrest. He replied back, "I'm good." I then went to put one handcuff on his wrist. He then pulled away from me. We then did that, back and forth. He was actively resisting. I did have another officer with me. He was able to slip away from both of us and take off running out the door as the maintenance guy was repairing the door. I was able to catch up with him as he got quickly tired, and I was able to handcuff him.
Okay. And were you at the time of this encounter in uniform?
Yes, ma'am.
And did you identify yourself as a police officer?
Yes, ma'am.
Your Honor, I don't have any further questions of this witness.
Okay, Mr. Copeland, do you have any questions for this witness? Unmute. Sorry. Can we unmute the jail?
Yes, sir. Go
Thank you.
ahead. Yes, sir.
Thank you. Mr. Copeland, do you have any questions of this witness?
No, no.
Okay. Let me ask a question. Officer, oh, Jesus. Can y'all turn the radio down, please? Over there at the jail?
Yes, sir.
Thank you. It's Officer Alexander, correct?
Yes, sir. Yes, sir.
If I heard correctly, the basis of this dispute was because the mother had access to funds that she's controlling or holding on behalf of Mr. Copeland?
That's yes, sir. Yes, Your Honor.
And so to your knowledge, and you may not know, is the mother still in control of those funds?
To my knowledge, no. I'm guessing the reason why she did have control was because of his mental capacity, I should say. But other than that, I do not know the basis to all of that.
Okay. What was there a reason why you didn't take him to a mental health facility as opposed to taking him to the jail?
Per other officers that dealt with him in the past, they advised they did that before, and that wasn't the first occurrence with him at that location.
Okay. Thank you, sir. Ms. Lewis, do you have any follow-up questions based upon the questions that I asked?
No, Your Honor.
Mr. Copeland, do you have any follow-up questions based upon the questions that I asked?
No, no.
Okay. Well, the evidence is sufficient to bind the case over to state court. So I'm going to do that. Just as an aside, it just I don't think this is a wise use of resources. But hopefully something will happen and this can get changed. So Officer Alexander, sir, thank you for your attendance here today. You're excused. Mr. Copeland can be returned back
Thank
to the jail or back to his holding location. Let me address Ms. Valentine really quickly. Ms. Lewis, was there a request filed to continue this case because the officer's on FMLA?
No, Your Honor. Traditionally, we would not file a continuance. The traditional practice has always been we update the court at the call of calendar with respect to our witnesses. And
So-
part of that is because of the tight turnaround from when we received the calendar.
How long has Miss Valentine been in jail? Mr. Copeland can be returned back to his holding location.
Looks like the incident occurred, Your Honor, December 1st.
Before. So this date was known presumably at least from December 5th.
No, Your Honor. So the way
Hold on one second. Hold on a second. Can we please return Mr. Copeland to his holding situation? Thank you. Sorry, Miss Lewis.
No problem, Your Honor. So traditionally, it's been modified in the pandemic from the way we would do it when it's live. We would have more notice generally when we're live and in person. The way the calendars are generated, typically, I become aware of the cases for Tuesday, on Wednesday, late Wednesday, early Thursday, the week before. So essentially, the state has about 2 or 3 days, if you don't include the weekend, to get the cases ready for the calendars. We're not involved in the arrest and prelim date unless sometimes attorneys may reach out to me in advance regarding someone in custody that they may want to talk to about a fast track or about consenting to a bond or something of that particular nature, but we're not otherwise involved prior to that. So we would not have that information at the time of arrest.
So, Ms. Lewis, you've raised an issue of notice as it relates to some of the requests that were made by Mr. Moore. As they would say, what was sauce for the goose is sauce for the gander, or however they would say it. How should I interpret your non-notice situation as it relates to this person is in custody, they've appeared today, and your officer is not present? And
I'm sorry, Your Honor.
no, and what I hear is you're saying, well, we would normally we'd show up to court and we'd say, well, the officer is not going to be present today.
Yes, Your Honor. And the difference in that is the notice, because the defendant receives notice of the court dates and the procedural posture of the case in magistrate court at first appearance. We're not present. Our notice
which can, and I'm sorry for cutting you off, which I would love for you guys to be present at first appearance, but I've been told that that's just, we decline.
So we're not simulated similarly. One, we have a burden. And so us having 2 or 3 days actually quite, honestly and candidly puts the state at a considerable disadvantage than everyone else who appears on the calendar. Because we have to both produce the evidence as well as secure the witnesses in a matter of three days. And traditionally, for a court appearance, we would have much more time. Particularly, let's say, for example, when we're in state court, we would have, usually 7 to 10 days. But we have a system in place so as to expedite and accommodate and make that happen as quickly as possible without potential delays. And so when we receive the information and we become aware of who's on the calendar, we then reach out to various agencies. And of course, as the court's aware, in the pandemic, people's hours and operating procedures are a little different. So a lot of times, because of our relationships, we're able to get things quickly, but that we always can't, that always isn't a consistent thing based on the pandemic. Additionally, as the court pointed out, we have the responsibility with respect to the Victim Bill of Rights as well. And so it is difficult to have people take off quickly and without such notice. And so a lot of times when we hear these cases, there were times where we'd hear bond cases, emergency bond cases for cases that were kind of languishing, had not transitioned from magistrate court to state court. We would still traditionally get about 10 days to a week of notice. And so the court still put that in place. So I'm not attempting to ask for anything that I think, doesn't take into account the position that the defense is in. Just my position would be, we are in a different posture because of when we do receive the notice. And although it's not a legal argument by way of jurisdictional practice, at least for my the period of time that I've been here, that's just always been the communicated means. But specifically with respect to bond motions, Judge George did put that in place, and that was kind of part of what my understanding was that we were going to have the requisite notice that cases would be scheduled and bond motions would be filed, just so that we could have that notice to witnesses. I certainly understand in Mr. Bryant's case, based on his charges, that the court may consider hearing bond. And I think that doesn't quite prejudice the state as much because it doesn't involve a victim. But for example, some of the other cases, family violence protection order cases, those are cases, one, the state would like to have more time to follow up on information related to bond, but also it helps with the notice issue with victims.
Let me follow your argument a little bit. How does what you just stated comport with first appearance hearings when a person is charged at a misdemeanor with committing an act of violence against a person, and that person is not represented in court by the state or by an officer, and a judge sets bond?
Because the notice is the right of the defendant. It's not the right of the attorney. And so
No. I'm talking about the Crime Victim Bill of Rights.
Oh, with respect, there are things in place to ensure that victims do receive notice with respect to that, because they also are entitled to be noticed if the defendant is released and things of that particular nature. There are things that are in place to make sure that happens in first appearance. However, with respect to, and again, my involvement with that is limited because we're not as involved, but as our position is here with preliminary hearings, we are positioned differently. And so that would be where my request is.
Which, when you say positioned differently, you're positioned differently because you received more notice, correct?
I'm sorry, Your Honor.
When you say respect position differently, how do you mean that? Let me ask that question first.
Well, with respect to preliminary hearings, our office is responsible for conducting those hearings. And so because of that, we are actively involved and have established practices in place to ensure that the Victim Bill of Rights is followed. And we have enjoyed, with respect to our relationship with the bench, kind of working with the framework that has been established with respect to that. Probable for the first appearance hearings, we're not involved in that. The person is arrested and they are placed in front of the court fairly quickly. So those are different established procedures and practices for those types of hearings and procedures. So that would be why we're positioned differently, because our involvement is not the same and our responsibility is not the same with respect to those two different sets of cases. The same way, like with respect to the other hearings that we handle in magistrate court, abandonment cases, we handle those, and those are processed differently as well for the abandonment pre-issuance warrant. So each hearing has its own separate established practice based on the state's responsibilities to those hearings.
Now, the Crime Victim Bill of Rights says whenever practicable, does it not? As it relates to the notice requirements.
It does, but I would be, and of course, at the current time, I mean, there's not a remedy, an articulated remedy in the state's Bill of Rights, but I certainly would not, in my office, would not be in a position to not notify, because what tends to happen is when these cases are heard or things happen without the victims getting notice, is then our office gets flooded and our office is held responsible for why that is or is not happen. We would not have the opportunities to have the same sort of conversations. Beyond the Bill of Rights, the state in it of itself as an actor is entitled to notice. And so it's kind of a twofold. Both we are entitled to notice and the victims are entitled to notice. And when you have cases on here in particular, I'm looking at the family violence order violation. I mean, that is certainly alarming. And to have a hearing heard on that, where there's already kind of at least alleged some sort of order in place to address violent conduct that is alleged to be violated. You know, I would think that the notice would be requirement would certainly be heightened. But you know, we have not just established as a practice that on the morning of that, you know, we're going to have bond hearings on these misdemeanor cases. And it has been established that, of course, with respect to the officers and their leave, that is the way that we've communicated it. Certainly we can adapt, but that has been how we have been handling it thus far. And so I relied on that practice in how I handled the cases today. But
so let's tie this back to Miss Valentine. It appears that what I heard from you is that you don't have enough time to file a notice to say that this officer is not going to be present, and you're going to request a continuance because of the short turnaround. So you can't do that, and you will arrive in court and say the officer isn't present. But as it relates to notification of the victim, you're saying, hey, it's okay that we don't have this when the defense shows up and says, Judge, we want to consider the issue of bond because we have the Crime Victim Bill of Rights. And even though the Crime Victim Bill of Rights says whenever practicable, in this instance, we need to have time. But in the instance of a person being held in jail and an officer doesn't show, well, it's okay. Person can just stay in jail and we'll just continue it and we'll come back to it. That's what I'm hearing.
No, Your Honor, that's not what we're saying. I mean, the officer is entitled to be out on Family Medical Leave Act. I mean, it's reasonable to expect in cases that people are going to be sick and ill. It's not that the state didn't do anything by way of due diligence, and that's why we're not able to have a witness here. I mean, a person has a medical condition. It's the same way the officer has shown up for 2 weeks on Mr. Pressberry's case, and he's not been able to be heard because he's in quarantine. It's not certainly something that Mr. Pressberry can help. And so witnesses are allowed to have those same issues with respect to that. The person is still in custody in part, and of course they have that right, but because they have been advised of their right to waive their case and expedite it past this point into state court, they've elected to have the hearing for this date. But I mean, that's not uncommon to have continuances needed because an officer's out on leave. And again, those dates are issued at first appearance. So this would have been issued back in December. So this person would have known for a month and a half now, and the state would have known 3 days ago. That is just a marked difference in notice of time. I mean, if someone has a month and a half notice versus someone having 3, they're not even closely similarly situated. And the state's request is not to continue it indefinitely. That we have ascertained when that leave would end, and we would be in a position to hear the case next week with respect to that office. So I don't believe the state is being dilatory. It's just a function of, life happening. And so I don't think that it's unreasonable to request a continuance under those circumstances.
And please, I'm not saying that it's unreasonable. The job of a judge is to follow the law. Every person that's charged with a misdemeanor is entitled to bond.
Yes.
And then factors come into play about what is an appropriate bond. And as a judge who sits at first appearance, you really don't have a whole lot to go on because neither state nor the defense shows up. So you just have the affidavit and you have the person's criminal history to try to determine what is an appropriate bond. A person that is charged with a misdemeanor that is entitled to a bond, this has nothing to do with FMLA for the officer. It's all about that U.S. citizens' right to not be punished before they're convicted of a crime. And in listening to you, I don't think you're understanding that being in jail is a punishment.
Well, Your Honor, respectfully, I do understand prosecution is not my first career. I was a defense attorney. In fact, I worked at Lister and Holt for several years. And my practice was to meet with my clients. And if I felt like it was, appropriate, we would move and we would waive hearings. And so I certainly understand being incarcerated and what that does to a person. I've had to visit clients. I've had to visit people in a non-legal capacity in custody, but it's not punishment. There's not been a sentence imposed. They are arrested, and as the court mentioned, they are entitled to a bond in misdemeanor cases, and bond is set. And so that is markedly different than if they were sentenced and were forced to serve some sort of sentence, because that is the appropriate or allocated punishment that is being doled out for the offense. But that's not the case here. The person is in custody. I assume, and I apologize if I'm incorrect about that they already have a bond. And so
No, they're entitled to a bond. They should have a bond set. I let me push back a little bit because you said something that I just want to be clear. You said being in jail is not punishment. Where do people go when they're convicted of a crime?
well, it depends. Some are released on probation and some may have confinement, but it's different in terms of punishment because, for example, I mean, they don't have to calculate pretrial confinement as a part of your sentence. So the law distinguishes pretrial, pre-sentencing custody versus custody imposed by a sentence. The sentence would be punishment. It's the same way I can reference a pretrial arrest and pretrial detention in a trial, but I can't reference post-trial consequences because the law distinguishes that as punishment. So from the legal standard, they are not treated the same, even though I understand physically they are in the same place. And the bulk of my day is actually spent processing and moving people through the court system expeditiously. In fact, quite a bit of my work comes from that. So I am not insensitive to it. In fact, the great bulk of my work is committed to moving people through the court processes quickly. But a request for continuance, when you look at the four Ayala factors, in terms of bond, and of course the court can consider things other than the Ayala factors, but those don't simply just always carry the day in terms of the ultimate outcome and determination with respect to bond. Certainly if the court is inclined to consider something different with respect to bond than what's already set, the state would provide that information, but it certainly puts us at a disadvantage in terms of being able to communicate to victims about that. And although we are spending a great deal of time talking about someone being in custody, I think we also have to have concern for the community. And I would be concerned as a citizen, and I would be concerned as a victim. If bond hearings were able to just pop up willy-nilly without the appropriate notice to be handled in tandem with the Victims' Bill of Rights, and also to provide the state an appropriate opportunity to fully prepare for them, I would be concerned about that as a citizen and as a victim of a case as well. And so it is a balancing.
No, go ahead. I'm sorry.
No, I apologize, Your Honor. I did not mean to cut the court off. So it's a bit of a balancing act. And so, like I said, I want to reiterate, I'm in no way, taking it lightly. That's why when officers do put in leave or things like that, I do try to figure out how long it's going to take to be out. But, no one is going to be at work 365, 7 days a week. They have to be able to be off. They have to be able to be ill when they actually are, and they're actually protected as an employee with FMLA.
Yes, Ms. Lewis, you keep going back to that. This has nothing to do with the officer. This has everything to do with my responsibility to the person that's in jail and my responsibility to the public. And I'm pushing back so hard on this is because based upon what I see so far, and just so you know, I was a magistrate judge back in 2007. So this isn't my first, time spent around this. And I've tried cases in federal court in 3 different states. I've tried cases in most states, in most counties, in the state of Georgia. I'm sitting here looking at a person who is in custody on a misdemeanor. And with the battery charge, there's ultimately a victim out there. And there's public safety. And there's the stuff I have to be concerned about. That if I were to dismiss this charge today, whether this person goes back and kills somebody tonight. And I don't have any answers to the questions that are in my mind about this case. All I have is the fact that we showed up today in officers on FMLA, and now I have to decide whether this case should be continued or not. And when you're weighing whether a case should be continued, you're looking at the charges. You're thinking about likely offenses, punishment that would happen, whether this person is going to be punished unnecessarily because of the decision that I make. So I don't make these decisions lightly. And that's why I am having this discussion with you and spending this time. And I'm sorry that I'm wasting other people's time. But I need you to help me place this into the best box. So that's why I'm having this conversation with you. And so I hope that you don't feel put upon, because that's not the reason for this discussion. I take it seriously, the fact that the decision that I make right now as it relates to this person means that that person is going to sit in jail. And with their case not getting moved an inch.
And I don't know if she intends to waive or not waive. I guess all we know at this point is she does not want representation by counsel. So she may want to waive.
And I wanted to have the discussion with you because you're a lawyer before I bring her up to see what she's actually going to say. But I just, I mean, I do take seriously my responsibility to the public and my responsibility. Well, my responsibility to the public means the people who are arrested and the people who may be victimized. So I do take that responsibility seriously. And it's not just eat another, knee jerk. So
And I guess just an understanding part of the court's concern. And I think that's why I kept relating back to the request of continuance, because it's the request for continuance that would, in effect, if she doesn't want to waive, prolong her into custody. And so I guess I'm trying to figure out if we somehow knew Thursday when we got the calendar that this was going to have to be continued because the officers and FMLA leave, and we would have made some sort of motion, would that have changed the court's position in having that because we would be unfortunately in the same position, the state, in terms of not having the officer here, which is what would keep the case from being heard today, and thus potentially having her wait. Although even if the case was heard and bound over, they would have to wait in custody until the case was, transferred to state court, accused and calendared there as well. So I just want to figure out from a standpoint of practice, what we could do.
So every day there's a calendar that's created because I've been doing it all year. So every first appearance, most of the year, 4 days a week.
Mhm.
Every day there's a calendar that's created. Every day, if your office deemed it as desirable, they could know that day the people that are getting scheduled 6 weeks out. The fact that they're saying, well, even though we can get access to the information, we didn't get access to the information. We waited for the information to be handed to us, and the information was handed to us at such a late time that we couldn't do anything about it.
Well, and Your Honor, let me just clarify, as the Chief Assistant Solicitor General in the office, that's not what I'm saying with respect to the practices and procedure. What I'm saying is, I am aware that those calendars happen daily. But our involvement with that is not daily. We certainly don't have the manpower. Our office is not set up to daily handle that as part of our responsibilities. And even when I did felonies in Superior Court, we were not assigned, we did not appear at the first appearance calendars. The involvement and how the state receives notice in order to do what we need to do, the state does not go out, and we would never be in a position to do that because we have to handle all of the cases, as opposed to a defense attorney who has a certain subset of cases they handle or a particular client. The way we receive notice are when we receive calendars. And so everything we do, particularly because of the volume of the misdemeanors, is driven by the calendar. And so that's why it puts us in that position. And if we don't have notice of that, and that's why we have to have things filed and served upon us, then we're unable to do the things that make court happen. A lot of the things that make court feasible to happen have to be a joint venture, both by the bench and the state. And I think that's because we are the government, and that's part of our role and responsibility. But we receive and have always received the notice on Wednesdays and Thursdays. Well, not always, excuse me. Since the pandemic, that has changed. We used to receive the information much more in advance when we were live, but we've just had to make those adjustments because, of course, this was not foreseeable. I certainly didn't think we'd be going into our second or third year of this situation. So the timeline has been very short. I think a lot of credit is due to the way our office and magistrate court and the staff in magistrate court work so carefully and have been so helpful to our office. That is the way we've really been able to make that adjustment. So I'm not saying we're getting it last minute. I'm saying both offices have had to make extreme adjustments that I don't know that other jurisdictions are making as seamlessly as we are. But in large part because of that communication and because, and I was joking with Miss Moultrie earlier, but because of people like Miss Moultrie and Miss LaFortune and the chambers, we've really been able to make these calendars happen when really, in theory, this process has been condensed down from a 2-week process down to a matter of a couple of days and getting it done. So I don't mean to, to have a cavalier concept of what it means in the greater picture of someone's total time of period incarcerated. And I do daily do things behind the scenes, and my office does things behind the scenes, things that go beyond what we are responsible for, because people are represented. They do have counsel. And even though they do that, a lot of times I am the force or Mr. Brooks or whoever is assigned that's pushing that case forward to be expeditious. So there is a great deal of effort going on behind the scenes that I think a lot of the government doesn't get credit for. And I will say the jail, magistrate court, the chambers and clerk's office and the solicitor's office really have done a lot in terms of trying to minimize when these types of things occur. But this was just unavoidable in Miss, I'm sorry, I apologize if I'm gonna butcher her name, Miss Valentine's case. So, I respect whichever position the court takes on it. It's certainly within the court's discretion. I just wanted to place on the record our concerns with respect to notice and the like in considering these matters on the preliminary hearing calendar.
Okay. I appreciate your willingness to have this discussion with me. The jail, if you can still hear me, can we bring up Miss Valentine?
Yes, sir. She coming up.
Okay.
Can you unmute her, please?
Ready.
Can you lower the camera just a little bit so we can see her face? Okay, thank you. Miss Valentine, good morning, ma'am. My name is Brad Gardner. I'm a judge of magistrate court, and I'm presiding over the preliminary hearings today. My understanding is that you do not want a lawyer appointed to represent you. Is that correct? I'm sorry, ma'am. I didn't hear your response.
No, I don't.
Have you hired a lawyer to represent you? Okay. Is it your intent to go forward today without a lawyer? I'm sorry, ma'am.
No.
The state is requesting a continuance for, my understanding, Ms. Lewis, and correct me if I'm wrong, is for 1 week.
Mhm.
Is that correct, Ms. Lewis?
Yes, Your Honor, that's correct.
Okay. Ma'am, you have the ability to respond in whatever manner you want to respond. How do you respond to the state's request for a 1 week continuance?
Mhm.
I'm sorry?
I'm trying to maybe complete the program.
Is there a language issue with Ms. Valentine?
No,
Can you speak English?
I know English more than Spanish.
Your Honor, she said she don't speak English.
I speak English.
You speak English?
Not Spanish.
You Spanish?
Yeah. No, I speak English. Not
You
Spanish.
speak English?
Yeah.
She's good.
Okay.
Spanish.
Okay, ma'am. Are you certain that you don't want a lawyer to represent you?
No.
It's your right to represent yourself. However, lawyers have spent time in school and they've spent time in training, and they may know issues that you don't know. As a judge, I cannot assist you.
Yeah.
I have to be a person that's in the middle.
Mhm.
If
How
your
much time I
desire,
have? How much time I have? How much time I have? Time.
so ma'am, that's one of the issues that a lawyer will tell you.
Mhm.
This is not the time to determine whether you are guilty or innocent or what punishment you will receive. That happens at a later date. If if you're choosing to represent yourself, you're going to be responsible for making those determinations. And whether it's the right determination or the wrong determination, you're going to have to live with whatever decision you make. I cannot be in a position where I am making determinations for your life. Do you understand that?
Yeah.
So the initial question that I posed to you was that the state, meaning Miss Lewis, is requesting a 1-week continuance
Mhm.
of your case, which means you will come back next Wednesday.
Mhm.
Do you agree or disagree with that?
I agree.
You agree?
Yeah. Or maybe the time that I got.
Okay. Ms. Lewis, do you have anything to add?
So Your Honor, I don't, based on her response.
Okay, Miss Valentine, what we're going to do is we're going to place your case on the calendar for next week.
Mhm.
Is there any reason why you don't want a lawyer representing you?
It's a long one. For a certain amount of time. But every time I had. The lesson, I came here again because I got assaulted. And then they're discriminating on my eyes all day and taking my family's, our family's life, you know? Everybody, a lot of people, and they don't know how to be like us, you know? So they gave me a turn. But I still had the same curfew time. So
Okay.
I don't see a time. Yeah, sure.
Okay. Thank you, ma'am. You can be Miss Valentine can be returned.
Yeah, nice day.
You too, ma'am. Her case is going to be continued to next Wednesday without objection. Miss Lewis,
Okay, sorry, we may be headed down the same path. I apologize, sir.
well, I'm certain when you were in law school that you were not thinking of these situations. And
Yes, sir.
sometimes it's the people in the margins that get lost. So I hope that your office will consider that as it relates to Miss Valentine. In my opinion, without someone stepping outside of the boundary, she's just going to be sitting in jail. And I don't think that's right for anybody.
Your Honor,
Your Honor, if I just may know, our office moves very,
Do you know that like they are trying to?
Hold on, Miss Mary.
Just,
Hold on. Okay, go
our
ahead, Miss
office,
Lewis.
our office moves pretty expeditiously. Once we receive the cases, it's a rare occasion that between the time the case is transmitted to our office to state court, that it takes more than 24 to 48 hours. And we do deal quite a bit. In fact, it's interesting that Mr. Moore is here. He and I actually used to be in the same courtroom. Mr. Moore kind of is the go-to, along with Ms. Gross for mental health at Lister and Holt. I do
I-
quite a bit on this side in dealing with these types of issues and do have background in accountability courts as far as mental health and things of that particular nature. So we do, when there are mental health cases, as part of the negotiations and disposing of the case in state court, those are the types of things we do consider and work with the defense on when we